Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions in the series, and today we are talking about the 4th question, which is holding interest in property. In other videos, we have introduced the takings clause, nor shall private property be taken for public use without just compensation. And we discussed the first major regulatory takings case before the US Supreme Court, Pennsylvania Coal versus Mann. In today's video, we are fast forwarding from Pennsylvania Coal 56 years to 1978, and the next major case to impact regulatory takings, which is Penn Central. Here we are dealing with another regulation. Of course, we're talking about regulatory takings. This is a land use regulation, the New York City Landmarks Preservation Law. This law was passed in 1965, probably in response 2 years earlier to the demolition of the original Penn Station. And this was a beautiful Beaux-Arts building that was pretty carelessly and stupidly demolished for what is now Madison Square Garden. It wasn't only New Yorkers at the time who were against the demolition. The fact that the building was demolished also paved the way for a national movement that helped to pass the National Historic Preservation Act a year later. So getting back to New York City, though, the Landmarks Preservation Law created an 11-member Landmarks Preservation Commission. It had professional members. One of its primary roles was to designate properties as historic, and another key role was to help make decisions about what kinds of changes could be made to those buildings that were so designated. Buildings over 30 years old with special character or historic value are eligible to be listed on the New York City's register. They can be listed either individually or as part of historic districts. The law imposes some duties on property owners. They have to keep the exterior of their buildings in good repair, but more importantly for this case, they also have to get commission approval for changes to exterior architectural features of designated properties. There are 3 ways for the commission to give its approval. So first, a certificate of no effect on architectural features, meaning there's no effect, so go right ahead. Second, a certificate of appropriateness, which allows modifications on the grounds that even though there is an effect, it is appropriate. And then third, a certificate of appropriateness on the ground of insufficient return. That means that for income producing property owners, there is some kind of economic hardship. So that's how the landmark law works. It works in concert with zoning laws on transferable development rights, or TDRs. This is key to the case. So to understand what TDRs are, you have to understand that each property in the city is allowed to build a certain number of square feet, usually determined by a floor to area ratio. So this is the size of the building relative to the area of the lot. So historic properties are equally entitled to build up to some maximum buildable area, but they often cannot maximize their built area because of historic district regulations constraining them. Okay, so got that? So it works in tandem with zoning. The New York City TDR program allows for owners of officially designated historic properties to sell their rights to develop that they otherwise would have had to neighboring property owners. The amount of development rights available to sell represents the difference between maximum development permissible under the zoning ordinance and the lesser amount of development that is available because of the historic restrictions. Landmark properties can transfer their unused development rights to immediately adjacent neighbors, properties across the street, or even properties on a block that's catty-corner to the block that the historic property is on. The receiving properties can be developed to a larger size than the zoning ordinance would otherwise permit. So for example, a building who received 5 stories of TDR credits would be allowed to build 5 stories higher than is permitted by the zoning regulations. There are not that many municipalities with TDR programs, but those that have them where demand is high are pretty smart because they are compensating property owners for regulation imposed losses at no cost to the municipality. So that is a lot of background about the TDR program. But again, it's important to understand how the court treats this case. So now let's talk more specifically about the development proposal itself. We are talking about Grand Central Terminal, built in 1913, a Beaux-Arts building, an incredible piece of architecture. If you've ever been, you know it's just a wonderful experience and a wonderful public building. It was designated under the city's landmarking program. Now, the owners of the property did oppose the designation when it came before the Landmarks Commission. But once the commission determined that it satisfied the criteria for historic review, the property owners did not seek any additional review to try to get it off the register. In 1968, Penn Central proposed to build a very modern office tower designed by brutalist architect Marcel Breuer. The plans called for the destruction of part of Grand Central Terminal facades. The proposed construction would interfere with views of the terminal from nearby streets. The plans were consistent with the zoning ordinance, but they were rejected by the Landmarks Commission. So the court here is attempting to resolve whether the city had effected a taking on the owners of the terminal. The key takeaway of this case, and I'm going to start here because again, this is a complicated case, is that the court establishes a multi-factor balancing test. The character of the government action, the economic impact on the claimant, and the reasonable investment-backed expectations of the property owner. So with these three factors in mind, let's see how the court evaluates the arguments from property owners, okay? So there are three aspects of the balancing test. Think about each of them as I talk about the arguments the property owners made. Their first argument was that the development rights are a property interest taken away by the landmarks law. The court rejects this argument. The commission could have approved another large building, it just didn't approve this particularly offensive design. So brutalism versus Beaux-Arts, not an easy juxtaposition, certainly not a compatible one. In addition, the court says the development rights were given a value through the TDR program. They could have sold to 8 nearby parcels. So the property owners not only failed to show they suffered an actual impairment, they also failed to show that the law impaired any present use. In other words, the property owners could still operate the building as a train station, which is how they bought it for and what its current use is. Thinking about the reasonable expectation that they had the reasonable expectation that it could be used as a transport terminal as it had for the preceding 64 years. And in fact, they were able to do that. So another argument from the property owners is that the law imposes financial hardship on them as individual property owners. And as a result, they bear an unfair burden and loss of property value. The court rejects this argument also. The court points to the fact that there is a comprehensive plan calling for the protection of historic structures and that the law is part of a citywide program involving 400 individual landmarks and 31 historic districts. Lots of these landmarks are close to the terminal and many do bear some burden, the court observes. It says that any law on general welfare will burden some people but not others, and that the property owners here may have actually benefited from the law. So here's where we see hints of the reciprocity of advantage argument that favors regulation and that is referred to by the majority in Pennsylvania Coal back in 1922. The court rejects this argument also, and in rejecting all of the property owners' arguments, the majority has weighed all of the three balancing test factors, coming down in support of the constitutionality of the landmarks law. So now we turn to the dissent written by then Justice Rehnquist. He wasn't chief yet. he sides with the property owner. The dissent says that Penn Central is bearing burdens that its neighbors are not, and that those burdens are more than the status quo. The property owners actually have an affirmative duty to maintain their properties under the landmarks law. The dissent also views TDRs as what you might say is imperfect compensation because they have an uncertain market value. Importantly, the dissent implies that we should never have incorporated TDRs into the analysis of whether there was a taking, arguing that whether TDRs were available is only an issue if we get to the compensation question. So, of course, the majority does not get to the compensation question here because they found that it is not a taking. So where are we now? The landmarks law has endured, and since this ruling, the number of properties it protects has more than doubled, with 70 plus historic districts covering 20,000 buildings and 1,000 plus individual landmarks. So some people say that this has driven up prices in New York City and constraining development. They are probably right about this. On the other hand, there is value to historic places that cannot be measured by economic calculations alone. Beyond New York City, this is an important case for local land use regulation of all kinds, whether that be zoning regulation or historic districts, aesthetic regulation, or other local land use controls, subdivision law. I think these are actually the most interesting and active issues in property law, and I really encourage you to explore those further with this case as your base. So with that, I will leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.